Hello everybody, and thank you for joining me for today's edition of Daf Yomi. Today's Daf is Shevuout Daf 49 Amud A. And I hope all is well. As you can see, it's a sunny blue sky day here in Manchester. So let's go. Amar Rav Huna. Any oath, including one incurred by rabbinic law, may be extended. What does that mean? The kol hamag galin v'chulo. If one has been required to take an oath by the court, even an oath of inducement, the opposing litigant may demand imposition of additional oath for any monetary claim he has against him, even if the opposing litigant does not demand imposition of additional oath. The court itself can impose oaths for such claims, as long as they know that such claims actually exist, as otherwise that would be like giving a litigant legal advice, which is the court is forbidden to do, so says the Shach. Nevertheless, when the hire worker takes an oath to receive his wages, an oath may be imposed upon him in accordance with Rav's interpretation of the opinion of Rav Huna. And that's in the Rambam Sefer Mishpat and Hilchot Torah and V'nitan 112 Shulchan Aruch Mitzvah 94:1. To render the person who takes it liable to take an additional oath, except for an oath of a hired worker, which may not be extended, since the hired worker's oath was instituted only to alleviate the concern of the employer. Now, Chesed says for everyone the sages are not lenient. The kol ein makilin. For anyone the sages are not lenient. Rashi explains Rav Chesed's opinion as being only slightly different from Rav Huna's opinion, and says they both relate to an imposition of additional oath upon someone who is already required to take an oath of some sort. By contrary, Midrash maintains that the topic is the initial oath itself, not the imposition of additional oaths, and explains that for most people the court is not lenient with regard to the oaths, and does not try to avoid implementing them. While for the hired worker the court tries to have him receive his wages without having to take an oath. The Rambam explains from a somewhat different perspective that in general the court is not lenient with regard to oaths, and advises that the litigant to refrain from taking oaths. The court is lenient for a hired worker and encourages him to take an oath in order to receive his wages. The Ran understands the Rif as holding that Rav Chesed explains that Rav Huna's statement, not that Rav Chesed disagreed with it, in that they extend any oath they incur to impose them additional oaths, except for hired worker for whom they are lenient. The Gemara asks, what is the difference between the rules of Rav Huna and Rav Chesed? The Gemara answers there is a practical difference between them as to whether the court initiates extending an oath for him. For any person who is liable to take an oath, the court is not lenient, except for a hired worker taking an oath for his wages, for whom the court is lenient and initiates the idea, telling him not to be perturbed by the oath, but to take the oath and receive his wages. This is in accordance with the Rambam's interpretation of Chesed's opinion, in agreement with Rav Huna's opinion. Rambam Sefer Mishpat and Hilchot Shevuout 11:9 Shulchan Aruch Mitzvah 89:6 and the Bar Hagua there. I.e., when the other litigant has not suggested it, the court extends the original oath to include an oath about other claims. The Mishnah teaches the bat school year abrogates the obligation to take an oath about a debt, just like it abrogates a debt. The Gemara asks, from where is the matter derived? Rav Gidol says, the Rav says, it's derived from the fact that the verse states, and this is the matter of the release. Every creditor shall release that which he has lent to his neighbor. He shall not exact it of his neighbor and his brother, because the Lord's release has been proclaimed. Deuteronomy 15:2. Since the word devar also means statement, this teaches that the Sabbath releases, I abrogates even a statement, I an oath. And the summary to Perek 7. The sage institutes that a hired worker who claims that he has not received his wages may take an oath and receive payment of his claim for two reasons. First, the hired worker's claim is credible, as the employer is distracted with managing his labourers, and it is likely he forgot to pay. Moreover, the livelihood of the hired worker depends on his being paid. Nevertheless, a hired worker can take an oath and receive payment only if there are witnesses that the employer hired him and he makes his claim before the end of the night, following the day he completed his work. Afterward, the claim loses credibility, as it is presumed that the employer will not violate the prohibition against delaying payment of wages. The right of the hired worker to take an oath and receive payment applies only to a dispute as to whether the wages were paid. But if he claims that he was promised a higher wage than he was paid, his employer takes an oath and is exempt from paying the higher sum. The state institutes that one may take an oath to receive compensation for being robbed or injured by another only when there is a prima facie evidence supporting the claim. One who claims that he was robbed must provide witnesses who testify that the defendant entered his house and removed items in a manner that shows that he did not receive permission to do so. Under such circumstances, his oath serves to grant credibility to his accusation of theft, at least with regard to items that it is reasonable to assume that were found in his house. One who claims that another injured him must provide evidence that the only reasonable cause of his injury was the defendant. Such circumstantial evidence alongside his oath is sufficient to support his claim for compensation. The situation of an oath associated with the storekeeper relying on his ledger is not one where the storekeeper's claims based on his ledger are incredible if he takes an oath. Rather, it refers to a case where the storekeeper claims that he paid an employer's labourers as the employee requested, while the labourers claim that they received no payment. Both the storekeeper and the labourers take oaths to support their claims, and they must take those oaths each in the presence of the other. They then receive payment from the employer, despite the fact that both claims cannot be true and one party must be lying. While discussing this topic, the Gemara mentions in a somewhat similar situation when two witnesses contradict each other, other testimony each set gives in other cases is incredible, but the testimony from a new set of witnesses composed of one witness from each of the sets is not incredible. When a defendant is a suspect with regard to taking oaths, such as one who has taken a false oath in the past, the oath is transferred to the claimant, who takes an oath and receives payment of his claim. If both litigants are suspect with regard to oaths, then the oath returns to the defendant, who is initially liable to take it. Since he cannot take the oath, he must therefore pay the claim. There are cases where the claimant sues for payments of a debt with the support of a promissory note is still required to take an oath. This occurs when the promissory note has been vitiated in some manner, e.g. by one witness testifying that the debt has been paid, by the claimant admitting that part of it has been paid, or when the lender wishes to be paid for the borrower's property in his absence. Additionally, heirs claiming payment of a promissory note issued to their father must take an oath that they did not receive any information from their father indicating that this note was paid. One who makes a claim on the heirs of an estate, referred to in the Gemara as orphans, even when he holds a promissory note, must take an oath that the debt is referred to has not been paid. Since heirs are not generally familiar with the business dealings of the deceased, the sages institute that one collects the debt from them only after taking an oath that the debt is extant. Some sages claim that when the borrower died before the lender died, the heirs of the lender cannot collect from the heirs of the borrower, as the father is liable to take an oath in order to collect, and one cannot bequeath an oath to his heirs. The Gemara concludes that this innovative ruling is controversial and should therefore not serve as a precedent in other situations. The sages also instituted an oath to be taken by partners and by those who manage the assets of others, even when an uncertain claim has to be brought against them. This oath is meant to clear them of any suspicion that they may have taken some of the assets unlawfully. The basis for this suspicion is that people who manage the assets of others are not always meticulous and sometimes grant themselves permission to take for themselves more than what was agreed upon. They also instituted that an oath may be extended in other circumstances. When one is required to take an oath, even a rabbinically instituted oath, his opposing litigant may impose other oaths upon him relating to any claims that he may have, even though he otherwise would not be able to impose an oath about those claims. The exception to this halacha is that the oath of a hired worker who claims that he has not received his wages, since he ought to be able to receive his wages even without taking an oath. The sages instituted the oath only in order to alleviate the concerns of the employer. His taking the oath may not be extended to having him take other oaths as well. Introduction to Perek 8. If a man delivers to his neighbor money or vessels to keep, and it is stolen out of a man's house, if the thief is found, he shall pay double. If the thief is not found, then the master of the house shall come near to the court to see whether he has put his hand upon his neighbor's goods. For every matter of trespass, whether it be for an ox, for a donkey, for a sheep, for a garment, or for any other manner of lost thing, of which one says, "This is it," the court of both parties shall come before the court. He whom the court shall condemn shall pay double to his neighbor. If a man delivers to his neighbor a donkey, or an ox, or a sheep, or any beast, to guard, and it dies, or is hurt, or driven away, no man seeing it, the oath of the Lord shall be between them both, to see whether he has not put his hand upon the neighbor's goods, and the owner thereof shall accept it, and he shall not make restitution. But if it is stolen from him, he shall make restitution to the owner thereof. If it is torn in pieces, let him bring it as testimony. He shall not pay for that which was torn. And if a man borrows something of his neighbor, and it is hurt or dies, and the owner thereof is not with it, he shall surely make restitution. If the owner thereof is with it, he shall not pay. If it is hired, he loses his hire. Exodus 22:6-14. This chapter will present the halachot of a type of oath known as an oath of baileys. It will describe when a bailey is liable for taking a false oath, and what he must do in order to atone for his transgression. Due to the fact that the halachot of baileys appear elsewhere, primarily in the 7th and 8th chapters of Bava Metzia, the Mishnah in this chapter will not deal with these halachot at length, and the Gemara will include only a few lines explaining the matter. According to the verses in the Torah, there are 4 types of baileys. One is an unpaid bailey, who does not receive payment or any other benefit until a safeguarding item. Accordingly, he has very limited responsibility and is not required to pay if the item is lost or stolen, and is certainly not liable in cases where the animal deposited with him died or was injured due to circumstances beyond the bailey's control. The bailey is required to pay only if he was negligent with regard to safeguarding the item or if he himself stole it. A paid bailey who receives payment for safeguarding the item is required to pay for it is lost or stolen or lost, but is exempt from liability to pay in the case of damage due to circumstances beyond his control. A borrower who receives an animal or another item for use without paying rent is always liable to pay for damage or loss, whether due to theft or loss or even mishaps that were caused by circumstances beyond his control. He is exempt only in a case where the animal died or the item was broken due to ordinary use, or if the owner of the animal or item was with him when the damage occurred. The halacha of a renter, defined as one who receives an item for use in return for payment, is not stated explicitly in the Torah, and therefore there is a dispute between the Tanaim whether his halachic status is similar to that of a paid or unpaid bailey. The Mishnah is according to the opinion that the renter is treated the same as a paid bailey. The Mishnah will describe a case where the owner of an item or animal demands that the bailey return his property, and the bailey explains why he is unable to do so. Consequently, the owner administers an oath to him with regard to his claim. The Mishnah will explain that at times the bailey may actually be lying and may still be exempt from bringing an offering for falsely taking an oath of the baileys. Additionally, it will detail what the bailey is liable to pay and how it is to atone for the sin of taking a false oath. In passing, the Mishnah will also add the halachot pertaining to a thief who is sued and who denies a theft and takes an oath. It will explain what he is required to pay and do in order to atone for his sin. There are 4 types of baileys. Arba Shomim Hain. The halachot of 4 types of baileys are discussed extensively in the Mishnah in Tractate Bava Metzia. They are mentioned here only in connection with the halachot of oaths. The Mishnah lists cases where one takes an oath to render him exempt, where he would otherwise have been liable to pay, and the cases where a bailey is exempt from liability so that the consequence of taking a false oath does not apply him, says Rashi. To whom different halachot apply? They are as follows: an unpaid bailey, who receives no compensation for safeguarding the item in his care, and a borrower, who receives an item on loan for his own use without paying a rental fee. A paid bailey, who is paid a salary for safeguarding a deposited item, and a renter, one who pays a fee for the use of an item or animal. In the event that one of these baileys is unable to return the deposited item to its owner, the halacha with regard to liability is dependent upon what happened to the item and upon the type of bailey. An unpaid bailey takes an oath attesting to the fact that he was not negligent with the care of the item and is then exempt from liability for everything. In the case of an unpaid bailey whose deposit was stolen or lost or stolen from him, or if the deposit was lost or damaged due to circumstances beyond his control, e.g. if the animal deposited in his care died or was captured, the bailey takes an oath of the baileys and is exempt. The borrower must pay regardless of the circumstances, whether the deposit was stolen from him or lost, even if the loss was due to circumstances beyond his control. The halachot of a paid bailey and those of a renter are the same. If the deposit was stolen or lost, they are liable to pay. In any circumstances beyond their control, such as if the animal is injured, captured, or devoured, they take an oath that the circumstances were under control, and they are exempt they are exempt from liability. And that's the Rambam Seif Mishpatim, Hilchot Shevuot 1-2, Shulchan Aruch Choshen Mitzvah 29-10-1, 303-2, 341, meaning for all types of damages, whether the item was lost, stolen, damaged, or if the animal died. Conversely, a borrower does not have the option of taking an oath and pays for everything, whether the item was stolen, lost, damaged, or the animal died, even if it was by an unavoidable accident. The halachot of a paid bailey and the rent are the same. They take an oath concerning an injured animal and concerning a captured one, concerning a dead animal, attesting to the fact that these mishaps were not caused by negligence, but rather by unavoidable accident, and they are exempt from liability. But they must pay if the deposit cannot be returned due to loss or theft, even if these were not caused by negligence. The Mishnah clarifies, if the owner of an ox said to an unpaid bailey, "Where is my ox?" Amna shemachinam, hichen shuri. In a case where one deposited the ox with an unpaid bailey, and the ox died, and the owner asked the bailey, "Where is the ox that I deposited with you?" If the bailey said, "You did not deposit anything with me," or "You deposited it but it was stolen or lost," and he took an oath to that effect, the bailey is exempt from bringing a guilt offering for false oath on a deposit. This is because, as an unpaid bailey, he has admitted the truth. Had he admitted the truth, he would not have been liable to pay in the case of the animal's death. Shevuout 8:5. When the unpaid bailey said to him, "It died," but the truth that it was injured or captured or stolen or lost, or if the bailey responded, "It was injured," but the truth was that it died, or was captured or stolen or lost, or if he responded, "It was captured," but the truth was that it died, or was injured or stolen or lost, or if he responded, "It was stolen," but the truth was that it died, or was injured or captured or lost, if he responded, "It was lost," but the truth was that it died or was injured or captured or stolen. In any of the above cases, if the owner of the ox then said, "I administer an oath to you concerning your claim," and the unpaid bailey said, "Amen," he is exempt. Amen potter. The bailey is exempt here, just as he would be in any case where his false oath is not needed to render him exempt from liability to pay. Same law applies whether he was in fact exempt, but took a false oath rendering himself exempt by means of another false claim, whether he was in fact liable and he took a false oath that nevertheless rendered him liable. This is due to the halacha that one is obligated to bring a guilt offering only in a case where his oath had the effect of rendering him exempt from monetary payment that he was liable to pay. Bringing a guilt offering, despite the fact that he took a false oath. The reason is that his false oath did not render him exempt from liability to pay. If the owner says to an unpaid bailey, "Where is my ox?" and the unpaid bailey said to him, "I do not know what you are talking about," but the truth was that it died, or was injured, or captured, or stolen, or lost, and the owner said, "I administer an oath to you concerning your claim," and the unpaid bailey said, "Amen," he is exempt from bringing a guilt offering, since he would not have been liable to pay in any of these cases. But if the owner said to the unpaid bailey, "Where's my ox?" the unpaid bailey said to him, "It is lost," and the owner said, "I administer an oath to you concerning your claim," and the unpaid bailey said, "Amen." And then the witnesses testify that the bailey consumed it. He pays the owner the principal, since he took the ox for himself. But if there were no witnesses, but after he took the oath he admitted of his own accord, the halacha is that one who rendered himself exempt from liability to pay by means of false oath, and then became liable to pay due to the testimony of witnesses, does not pay the additional 1/5 and does not bring a guilt offering. This is because both the 1/5 and the offering are meant to atone for his sin, and the atonement is not possible unless the sinner repents and admits to his sin of his own accord. That he stole the ox and took a false oath, then he pays. A bailey who robs or steals from or oppresses another by withholding his deposit, and then denies the claim against him or denies having received the deposit, and takes the false oath to assert his claim, is liable to return the principal, and if he admits his guilt, he must pay an additional 1/5 payment. Additionally, he is required to bring a guilt offering for robbery, and this is due to the halacha that in cases where one would be liable to pay were he to admit his guilt, but instead he first denies and takes an oath. Once he admits it, he pays the principal and the additional 1/5, and he also brings a guilt offering. But if witnesses testify and he still denies the claim against him, he pays only the principal. This is because the 1/5 payment and the offering are intended for atonement, and atonement cannot be achieved unless the defendant admits his guilt. And that's the Rambam Sefer Nazich and Hilchot Zayda for Veda 7:1-3, Sefer Flam, Shevuout 1:8-10. The owner the principal and the additional 1/5 payment, and he brings the guilt offering to achieve atonement, as in any case where one takes the false oath with regard to a deposit. Similarly, if the owner said to the unpaid bailee, "Where is my ox?" and the unpaid bailee said to him, "It was stolen," and the owner said, "I administer an oath to you concerning your claim," and the unpaid bailee said, "Amen," then the witness should testify that the bailee stole it. If a bailee claims that a deposit was stolen from his home and takes an oath to that effect, and later witnesses come and testify that his claim was false and that the deposit was in his possession at the time of his oath, he pays double the principal, as he himself is the thief. If he slaughtered or stole the deposited animal after he took the oath, he pays 4 or 5 times the principal. He does not bring a guilt offering for taking a false oath in presence of witnesses, nor does he pay an additional 1/5 payment. I'm going to say for the Hilchot Geneva 4:1. There's a difference between a bailee who was negligent or took the item for himself and the bailee who falsely claims that the deposit was stolen. This is because the Torah states in Exodus 22:6-8 that the latter is treated as if he himself were a thief and is liable to pay double, says Rashi. He pays double the principal. If he admits of his own accord that he stole it, then he is exempt from double payment for theft, but pays the principal and the additional 1/5 payment and brings the guilt offering to achieve atonement. If the owner of an ox said to someone in the marketplace, "I, a stranger who was not a bailee, where's my ox that you stole?" and the accused said, "I did not steal it," and the witness testified that the accused did steal it, the thief who was convicted on the basis of testimony of valid witnesses is able to pay double the principal and to the owner of the stolen property. If he slaughtered or sold it, he pays 4 times the principal if it was a sheep and 5 times the principal if it was an ox. I'm saying from the Zich and Hilchot Geneva 1:4-6. He pays the double payment. If he slaughtered or sold it, he pays the 4-fold or 5-fold payment. If the accused saw witnesses that were approaching, if one admitted in court that he stole, and later witnesses came and testified that he stole, he is exempt from the double payment, as he renders himself liable to pay the principal before witnesses arrived. I would say from the Zich and Hilchot Geneva 3:9. So against him, and at that point he said, "I admit that I stole the animal, but I did not supposed to sell it." He pays only the principal. If the owner said to the borrower, "Where's my ox?" and the borrower said to him, so I moved on to the next Omid. Thank you for listening and wish you a very good day. All the best. Bye.